Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. What we're talking about here uh, are all of the different provisions of 245I and how it works. So, again, if this particular 245I video does not answer your questions, uh, do a search and you'll find many others that I've done on the same subject, but different aspects of it. Now, I get asked a lot of times, what happens if the petition is denied? Well, 245I is normally still available, minus some exceptions, even if the petition were denied. So let's say, for example, that you had a spouse that filed for you, a lawful permanent resident, under 245I, and then before you ever got your green card, the spouse divorced you, left, and said adios. In that particular respect, you're still under 245I, and you can file another petition, whether it's family or employment based, and once that visa number becomes current, you're able to adjust and pay the penalty. So, for example, if your spouse left you, and 7 years later you marry a U.S. citizen, you are able to file immediately the adjustment application under 245I. Now, same thing with the employment based. Let's say that employment uh, the employer who filed for you went bankrupt before you were able to obtain residency. Same thing, you could file a new family based or new employment based, and eventually you would be able to adjust status to that of a lawful permanent resident, even though the new application that you have filed is completely different than the one that was originally filed under 245I. Okay, more on the coming videos.